Evening, everyone. We are on the record. Today is Monday, the 11th day of May, 2026. This is a regular meeting of the Rent Protection Special Investigation Committee. We had a scheduled 5 p.m. start on the clock. My cell phone is showing 5:16. May we have a roll call for the commencement of the meeting? Councilmember Labarro.
Here, for the record, I have to leave by 7 p.m. to go to another community meeting.
Councilman Tom Jazupa.
Easy.
Just ask that you talk into your microphone so we can get you on the record. Councilman Gilmore.
Present.
Councilman Efros.
Present.
Councilperson Little.
Present.
And Councilperson Singh.
Here, for the record, I was here at 4:56.
We have 6 council members in attendance at 5:16 p.m. Can we kindly rise for the salute of the flag? Would anybody like to do the honors? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. You may be seated. On behalf of the members of the Rent Protection Special Investigation Committee, in accordance with the New Jersey Public Laws of 1975, Chapter 231, the Open Public Meetings Act, also known as the Sunshine Law, adequate notice of this meeting has been provided by posting on the bulletin board of the first floor of City Hall. In addition, at the time of its preparation, the notice of this meeting was similarly disseminated on Monday, May 4th, 2026 at 3:43 p.m. to the Mayor, Municipal Council, Business Administrator, Corporation Council, and the local newspapers, and posted on the city's website so that I can certify as to our total compliance with the Sunshine Law. Now, Councilman Gilmore, as the chair, would you like to get started?
Yes, good evening, everyone. So what we'll do is, how many people is here to present? Wait, don't we have, is this the meeting where we have additional,
We can ask them all to introduce themselves to get started, but
I know that, but is Jake coming today too, or is that a separate meeting?
No.
Okay, all right, so we'll do, introductions, and then we'll go from.
Good afternoon, Chairman, council members, committee members as well. I would like to introduce myself. It's a pleasure to meet you all. I may have met many of you already, but I'm the acting chief municipal prosecutor, Vishnu Kemraj. I'll let my colleagues introduce themselves as well.
Good afternoon, council. Thank you for having us. We're excited to present for you. My name is Graham Fleetwood. I'm an assistant prosecutor who works with Housing Code.
Good afternoon, council members. I'm Joe Barrow, Director of Code Compliance.
And good evening, council. This is Ryan Spain. Glad to be here.
Ryan, your function, Ryan. Your function?
Oh, assistant prosecutor.
Assistant, okay. All righty, so as you know, this committee have been formed to look into the issues as it relates to housing violations and things of that nature. So I guess we can go with the prosecutor. First, we'll ask the questions. We have a list of questions. Were you guys given the list? Do you have lists?
I was not supplied with a list of questions.
we provided them with a list of topics. The list
Well,
here
that's what I mean.
is a draft. Yeah, broad topics, but this is a draft. Not all council members had a chance to put their questions on here, so we can go in order of here. and
Yes.
We can go to the others who did not have a chance to put it on there.
Yes. All right. So in light of all that, Councilwoman Singh is up first.
Sorry, I want to say I do not want to ask question right now. I'll ask when I'm ready. I'm not ready right
Oh,
now.
you're not, okay.
I can go.
Okay. Well, they have a brief synopsis of what we're. All right, so go ahead, Tom.
Good evening, everyone. I didn't submit questions in advance, but none of my questions are going to be surprises to you. That they go off of what my colleagues had submitted previously in terms of topics. And we're starting with the prosecutor, correct? And then we'll ask Mr. Barrow questions later. All right, sir, how many cases did your office handle in calendar year 2025?
If you're looking for exact number, I do not have that number. I can tell you on average, a typical court calendar is 40 cases. We have 3 sessions per day. We have a morning session, we have an afternoon session, and we have an evening session. Evening session is the only time they do not meet is on a Friday evening. Otherwise, that's our typical calendar size. To give you an exact number of how many cases we processed in 2025, I would have to try to get some sort of data of that. The appropriate, I guess, query for that processing would probably be the municipal court, but I can certainly speak with the court administration about that.
Okay, and that's some information you can get to. So for example, every time a summons is issued, there's a number associated with it. So we would know, you should be able to ask the municipal court administrator, and then you should be able to know, answer my next question too, I would imagine, which is, what was the amount of fines recovered or issued? Actually, let's backtrack. What was the amount of fines issued that your office handled in calendar year 2025?
Yeah, once again, you're asking for specific data. I want to first address the question about fines. The prosecutors are there to reach a just result. They are there, their function as a municipal prosecutor, as an assistant municipal prosecutor, is to find justice. We are not driven by fines. We are not driven by convictions. We are there to, as the gatekeeper, so to speak, to make a decision if prosecution is warranted. Many times that's a determination of if probable cause is proper for us to proceed. Then we go through a process of plea bargaining, reviewing reciprocal discovery. That means discovery provided by our adversary, the other side, and we make a determination based on that information of the, how that course should be taken in that prosecution. We are not there for convictions. We are not there to reach a certain dollar amount.
Correct. Your role is to do justice and to make sure justice is done. I was a prosecutor for the county for 4 years. I'm fully aware. All I'm asking about is if you are, as the acting municipal prosecutor, are aware of what the amount of fines that were issued that your office handled.
I can certainly try to get that data, but we collect certain information, not of every fine taken, but that's an internal information. We do not take a tally, so to speak, of every dollar amount that when a defendant is found guilty of what fine is assessed.
It would be fair to say you'd also be unaware of the amount of fines that were recovered or received as a result of prosecutions by your office. The reason I'm asking, to be fair, is because this body is going to have budget hearings soon. Obviously, every municipality should know how much money is being budgeted for our prosecutor's office, how much money is coming back in terms of fines, not just on housing issues, but other issues. But I will take it that you do not have an answer yet there, and you're going to get that information from me. I appreciate it.
If I may add,
Yeah.
Councilman, it's my understanding that the municipal court, does retain some sort of revenue number that they process. Now, I want to explain to this committee, we may prosecute a case. A court may find that person guilty and assess a dollar amount, and whatever prosecution that is. That's one number. What is actually collected, that means the defendant actually paid, is a separate number, right? So there's a certain distinction as to if you're saying revenue that's been generated or fines collected. I can probably surmise that the municipal court can get you that data.
Right, because there are certain fines where the municipality, the city will take it. Otherwise, for every plea or guilty adjudication, there's $33 in court costs, $7 fine, right? And then there's, of course, a $3 credit card fee if you do it online. So what I'm asking only is how much money if you know, in terms of fines that were recovered as a result of prosecutions from your office?
I believe Corporation Counsel might be able to address that.
2024, 10.9 million, 2025, 18.3 million, year to date, 6.4 million,
What was the second number, Sarah? 18.3,
18.3.
25.
I
Sir,
can share the detailed breakdown with you all month by month.
Thank you. And that was for 2024, 2020, and 2025?
And then years.
2024 is 10.9, 2025 is 18.3. There was a big jump from 24 to 25.
May I be asking Corporation Counsel, do you know how many cases resulted in dismissals that were filed in municipal court?
I do not.
Just know for the record, I'm requesting the number of dismissals in 2025. How many cases resulted in dismissals in 2025? Mr. Prosecutor, what number of cases did your office handle in calendar year 2025 involving housing violations?
Okay, I'm not sure of an exact number that we handle. I can tell you the amount of sessions that are generally code heavy. When I say that, and I just want to clarify, are you asking about municipal code violations? Are you asking about state agency code violations? What code violations are you referencing?
I'll take any information you have available to give to me today.
Okay. So the majority of code we handle is from the municipality. We don't track the specific numbers. We do, from our code compliance, we do see the amount of summonses, an estimate of how much they have issued. Obviously, there's several other agencies that issue. So I'll see if Director Barrow has an idea.
Our office issued 20,000 summonses last year.
Okay. Director Barrow, do you know how many of those resulted in adjudications?
I have no idea.
20,000, you said, Joe?
We issued 20,000 summonses. That's not counting all the housing violations that we've.
In 2025, yep.
I won't ask numbers again, because it's clear at this particular hearing, the witness is unaware of how many cases were filed. But can you speak to the process of dismissing a based on prosecutorial discretion?
Absolutely. There's several factors that we consider, and when we receive a case, we make an assessment. One, can we meet our elements, right? Every offense has an element to it. In order for us to meet our burden, then we have to prove that beyond a reasonable doubt. That's the highest standard. If we cannot meet one of those elements, we cannot prosecute, right? If we can meet those elements, obviously we can prosecute. In municipal court, throughout the state, throughout the country, there's plea bargaining. When a defendant is facing several summonses, there may be a plea to some, maybe a dismissal to others as part of that plea bargain process. Because quite frankly, we just can't take every case to trial. We would never process every summons that was issued if we had to try every case.
How many cases were tried in 2025 by your office?
We do. I would love if these questions would have came to me beforehand, because we do keep some stats internally that I could have provided you with some specific numbers.
But you're aware you're appearing today to discuss your office's response to rent control and housing summonses, correct?
Yes. And it was my understanding that I would have gotten some sort of structure as to the line of questioning. Many of this is not related specifically to rent. So I wasn't sure what exactly the committee was looking for. And I'm more than happy to provide those internal statistics that we keep.
What I was asking specifically about the prosecutorial discretion was does one of your prosecutors have to come to you and say, hey, I don't think I have a case here. I don't think we can meet our burden. What's the internal process before a case can get dismissed for prosecutorial discretion?
Sure. If there is a question by an assistant prosecutor, yes, they do come to me for that discussion. They do have that independent discretion. As I mentioned earlier about the quantity of cases, we have very skilled prosecutors in our office, and they are quite aware of what our expectations are, what our standard is, what the law is, importantly, which we are within the confines of the law. So we have to comply with what our ethical requirements are, as well as our legal requirements.
For our housing related issue specifically, does your office have a mechanism to reach out to the tenant before the court date?
We do not, unless we have a specific witness. If the complaining witness is a tenant, then we will reach out. The question becomes if we can meet our burden of proof. Generally, in code violations, it is the code inspector doing the inspection, finding the violation, and issuing the summons. If we can meet our burden based on that information, then we don't need to reach out to anyone else other than the inspector.
How about for repeat offenders? So for example, if you have a tenant who files multiple complaints, is there any concern about making sure that those complaints are abated in addition to perhaps a fine being issued by the court?
Absolutely. So we have an internal file system, albeit not a case management system, which actually went down a couple weeks ago because of the amount of information we store on there. Our capacity well exceeded the limit, and we need funding to actually get a case management software. But what we do is we track properties internally. Since we implemented that system several years ago, we have a history. We keep notes. We understand what a prior history is of a property, and that obviously influences us when handling a matter going forward. So if there is a repeat offender, they're going to be treated very differently than if you have a person that has owned the property for 20 years, and this is their first time in municipal court on a summons.
How is that tracker kept? Is it a piece of paper? Is it a computer or spreadsheet?
Yeah, it's on, I don't know if you're familiar with SharePoint, Microsoft SharePoint. It is not a case management software, and it's something we need. We've looked into it in the past. For budgetary reasons, we were not able to do that. And that's something I think this committee can assist us with to more effectively capture our information, is to, like every other law firm in the state or throughout the country has a case management software that they can effectively use. We are making do with limited resources.
But let me ask that on that point. I'm almost done. I'll yield it shortly to my colleagues. How many prosecutors do you have currently?
Right. Currently, we have 6 prosecutors. One of them is currently out on leave.
Okay. How many of them are assigned to handle housing violations specifically?
They all can handle code violations. Mr. Fleetwood, Assistant Prosecutor Fleetwood here, primarily handles code, and we have Assistant Prosecutor Ryan Spain also handles a large amount of code.
What tools does your office have to locate the owners of an LLC?
Yeah. So once again, we're limited on that as well. For a while, we've been seeking to add a skip tracer to our office, but we need the budgetary resources to do that. So right now, in order for us to do that, we would search the state website. We would search registered agents. We have access to LexisNexis. It's a legal program. That's our limited resources at the moment to try to obtain landlord information. Also, we have coordinated with HEDC, where through the landlord registration, they share us that information. So if a landlord is registered their property, we have the latest contact information from regarding that property based on that registration.
Councilman, I just have follow-up question. Can I ask? When you were talking about these cases, is it a public information? Suppose I am a repeat offender. Can I find my information online?
I don't believe there's a public database for code violations.
So,
All right, so following up on that, so I know one of the tools for, let me ask it this way. The tracker you referenced, are you seeing that summonses are being issued to repeat offenders, repeat slumlords, and they're not coming into court? And if so, what steps are you taking to make sure we have some sort of justice for those individuals?
Okay, so for landlords that fail to appear, just permit me a little time because it's a little extensive explanation. We have something called, for landlords that are companies, entities, like LLCs, we utilize something in the court rules that permit us to go take them to trial. It's called trial in absentia. At their first appearance, if they fail to appear, the court has the opportunity to enter a not guilty plea. They send out certified notices pursuant to the court rule. If they fail to appear, we proceed with a trial in their absence. Once we proceed, we have a full-blown trial, right? As we would if the adversary was present. And then the court enters a decision. The court enters a decision. There's a decision where fines are rendered. Then we ask that be a written order. Then we convey that to the law department to eventually put a lien on the property. Another avenue is penalty enforcement hearings. Penalty enforcement hearings are where we are just simply enforcing the penalty, where our jurisdiction is simply civil in nature. An example is from the fire department. They've done their inspection. They provided the notice to the landlord. The landlord has failed to abate. They assess the penalty. The landlord has failed to pay that penalty. Then they issue the summons to us for penalty enforcement, where our only objective there is to enforce the penalty that has been assessed. The court makes a determination if that's a reasonable penalty. And if it is done, then ultimately we once again try to get a judgment.
If you can ask, I'm sorry, let me ask a question on those notes. If you can estimate how many trials in absentia has the office conducted in the last year?
So currently we do trials in absentia every Monday, every Friday. Now we're implementing them on Wednesdays as well, every Thursday nights for each session. This can be about 30 tickets maximum per session, and we've been doing that for about 2 years now.
How many liens have been placed on property owners in absentia?
I believe last count was upwards about 50. We have about 50 more that are ready to be docketed for judgment. Implemented a policy of setting 1 day to fill all the judgment liens out once a quarter, so that we can keep track of all these time payments that we get, all the fines that we get, and we can process them, send them to the law department for docketing.
All right, and last set of questions here is about conversation with your fellow employees from the housing departments. What, if any, conversations are happening with housing during the process from the time your office receives a summons to prosecute and the adjudication?
Sorry. We are in contact with our witnesses, whether it be from housing or any other department. That SharePoint system that I referenced earlier, we have connected these different agencies on that system. They can upload the information. They have the ability to, instead of picking up the phone, calling us, explaining to us, they can input that information into our case notes. So we already know what their position is, what their thoughts are. So there is not, we're not taking away from their day where they have to answer phone calls or address questions or inquiries we have. So we constantly communicate not only with that department, but other departments throughout that city that we prosecute on.
But in my last question, at least my opinion of what's going on with some of the bad actors throughout the city is that going to municipal court, getting fines, going through the process is part of business for them. It's part of the cycle. It's part of doing business. It's part of it's a game they're playing with the city. So what steps do you envision being able to take to engage with the tenants who are filing the complaints, because they'll have the best knowledge, they'll have the history, that it's their own experience, as opposed to a compliance officer or inspector who's issuing tickets and perhaps is not as, certainly not personally invested as a tenant would be.
Right. So only thing I would respectfully say is we certainly can engage with tenants. However, for a fact witness, our inspectors are the more appropriate party. You have a biased opinion, maybe biased, maybe not biased, but a court potentially can see somebody has a vested interest or ulterior interest sometimes when they're providing testimony. When appropriate, we do use tenants as witnesses. Otherwise, if we can, otherwise we use our inspectors, or in addition to our inspectors. The issue that we find as these landlords recognize that they're responsible when they're, ABC LLC. And then what they do is they transfer that property to another LLC. And then they transfer that property to another LLC, and it's a complete game, right? If we had the manpower, right, and this committee and council can certainly provide us with that, we can look into piercing that corporate veil, because generally you're finding that's the same members for ABC LLC, 123 LLC, 456 LLC. But, that's something I think if you equip the law department, if you equip my office, that is something that I think can be addressed. Right now, we're just struggling to maintain status quo because we are down on staff, right? If this committee, this council can provide us with the budgetary resources to increase our prosecutors, we would have the ability to do much more, right? We have a substantial amount of cases that need prosecution. In fact, we have a judge that is sitting in the evening. Right now, he currently only handles Parker's because we don't have an assistant prosecutor to provide that judge to address other cases.
Did you say Parker's?
Parking violations.
Because the
Yes.
prosecutor's office doesn't handle parking violations, correct?
That is correct.
Okay, so
Yeah.
that prosecutor, you don't need a prosecutor for that particular judge, because many years ago, there was a scandal in municipal court and the prosecutors don't handle, it goes straight to the judge, right? There's no prosecutorial discretion for parking tickets.
Correct. Correct. They're self-proving documents. They're self-proving summonses pursuant to the statute. They are, quite frankly, it should be simply if the litigant is guilty or not guilty. So either plead guilty or they want a trial. The burden shifts to that defendant to prove that they are not guilty of the offense, and then the court should be making a decision. I do want to add that there's a significant backlog of code cases. Right now, there's approximately 50,000 code cases that need to be scheduled, but they're not because of the limitation on those resources, right? Limitation on judges, limitation on prosecutors. With the manpower, that can significantly cut into that backlog. And this council has the ability to do that. And I implore you all to consider that, because having the ability to address those will certainly help the city, I believe, in the long run, to address bad actors, to address bad landlords. And the only way we can do that is by addressing those cases and holding those landlords or litigants accountable. And I'm not saying there are good landlords out there, there are bad landlords out there. right? That's the role of of the prosecutors. So when we get a case, we make that assessment depending on the history of that property, depending on the history of that defendant, will determine how we address it. Just like in a criminal case, we treat it the same way in a code matter.
Mr. You done, Tom?
Sorry,
Just the last point is, Mr. Chairman, if I could request the information that I had asked for, which is the number of dispositions, number of cases, number of fines issued, because for the second consecutive hearing we have, it's not your fault. You should be advocating for your office, and I appreciate that. The witnesses who are saying they don't have enough money, don't have enough resources, and neither of them have brought this council or this committee information on how much of what their offices are doing in terms of numbers and fines. So I request that information. I'll yield the rest of my time. Thank you.
All right. Mom, so you have a,
just the follow-up question. You said that ABC LLC start another LLC. How do they change the founder owner's name? Because even if you start multiple LLC, the contact person's information cannot be, how do you?
So if I may just give you an example, ABC LLC buys 280 Grove Street, right? They accumulate summonses. They go and sell it to 123 LLC, right? Same members, but the owner of the property is the entity, right? And the whole reason companies are brought is to protect individuals unless they're doing something wrong. They're violating their fiduciary duty. It's a much higher burden to go after that individual. The whole point of having a company is essentially to have a shield.
yes.
Yes, but you do get unique number. It is little complicated than I feel the address verification and everything is done when you start a new LLC. So I'm just wondering how this one landlord decide to have multiple LLC.
Well, interesting enough, and I would love to go into detail with all of you so you understand what happens is these landlords have multiple layers of LLC. The owner of the property might be LLC. Their registered agent, which you're required to have, will be an LLC. And then that registered agent is an LLC. You have layers of LLCs that are essentially they're trying to best shield the individual that's really the actor, right? And the whole reason they're making these companies is to evade the actor themselves getting into trouble.
Mr. Prosecutor, so just let's stay on LLCs for a minute. And just a FYI, we understand the sentiment that every department needs more resources, but the reality is we are on a shoestring budget and we're going to have to make do with what we have. So I do want to allow Councilman Afros to ask questions, and anybody else who have questions as it relates strictly to the LLCs. And
Councilman, if I may, just mark Councilman Griffin present at 5:36, so we have all 7 committee members in attendance.
Can I just quickly just address your point, and I respect what you said, Chairman. I personally believe the cost benefit analysis will address that issue. I mean, based on processing of cases and ultimately the outcomes, although we are not fine driven, we are justice driven.
So Mr. Prosecutor, in light of all of that, in your assessment from a financial standpoint, what monetary allotment of money do you feel your office will need to help pretty much go after these bad actors and tracking down these LLCs and things like that?
Well, let me just say, ideally, there are 6 sessions in the morning, 6 sessions in the afternoon. If I had, and we're talking ideal world, and I don't know if we will ever get there. If we had 6 prosecutors, 12 prosecutors, 6 in the morning, and in the afternoon, they're specifically addressing their caseload, digging and identifying, using that time, because I want this council to understand when we work, we are not a 9 to 5 personnel for the city. We are on 24/7. We are preparing into the evening. We are preparing before early in the morning. I have prosecutors that come in at 6 o'clock, 7 o'clock in the morning, and prosecutors that are leaving late at night, taking work home, come in on the weekends. We are a 24/7 hour efficient prosecutor's office because we believe, in reaching justice. Now, what that means, we write briefs, legal documents or arguments that we have to put forth. We address motions. We have to do all that work beyond physically being in the courtroom. In order to achieve our goal, we need to do the legwork before the case even is in court, and then after. Obviously, for preparing for trials and things like that, that's, an all-night event, all-week event, all-month event. Just so this committee knows, every week I have a prosecutor meeting every Wednesday at noon where we go over all our trials and abstentions, all our motions. I take that opportunity to ensure if any of the prosecutors have questions, we address those questions and we handle them. If it's strategy, if it's a legal issue, whatever that may be, we want to make sure we're on full throttle and everybody's at the maximum efficiency.
So I guess I don't want the question to get lost. Is there a monetary amount or
Okay.
manpower amount which will help you to effectively do the business?
Manpower. And the reason I say there's no monetary amount, because depending on the person you bring on will determine what their pay scale is, but it's a manpower.
And you're down how many people? 6?
So right now we have 6. I want to explain that we have 6 courts in the morning, 6 courts in the afternoon, 5 courts in the evening, right? That are going. And we only have 6 prosecutors. We do in the evening have some help from the law department in those evening courts. Just a couple weeks ago, we were down 2 prosecutors because of leave for many months. Right now, we are down just 1. So we're down to 5 assistant prosecutors struggling to cover 6 courts.
Jake.
Thank you, Chair. Thank you for coming and agreeing to walk through all of this with us. On the note of LLCs, limited liability companies exist pursuant to New Jersey Limited Liability Company Act, NJSA 42.2 and 42.2B, 42.2C, wherein they have any lawful purpose is an entity distinct from its members, and therefore the debts, obligations, and other liabilities of an LLC, whether arising in contract, tort, otherwise, are solely the debts, obligation, or other liabilities of the company, and they don't become the debts, obligation, or other liabilities of a member or manager solely by reason of the member acting as a member or manager acting as a manager. I'm not telling you anything you don't know, of course, but I just want to get that for the record, that we have this issue, as you were explaining before, of the distinction between the person, often referred to as the natural person, someone making money off of a business, behind the LLC and the LLC itself. And it seems like we are encountering some issues in addition to just the staffing issues here with the LLC question. The state of New Jersey versus Joseph Ehrman in July 2021, there were 25 complaint summons against Joseph Ehrman, a prolific Jersey City landlord. Court found only the LLC was guilty of the violation, and Joseph Ehrman has, I don't know how long of a list of LLCs, from the Heights to downtown, West Side. And Ehrman goes in court, argues that because the properties are owned by an LLC of which he was a member, rather than by him individually, complaints were fatally defective on their face. The decision was that the state court this was appealed from municipal court. State court reversed and remanded the municipal complaint summons, vacated the record of conviction as to Ehrman individually. And so it leaves me wondering that we have this system where tenants are left to file petitions against natural persons. If you are filing a rent violation petition, rent hike, right? That is in violation of Code 260, or if you're filing a petition as a tenant around harassment from your landlord, you have to name, if I'm not mistaken, the natural person who is your landlord behind whatever LLC, but then you can go to court and they can get thrown out. The summons can get thrown out, violations can get thrown out because that person is no longer liable. So I'm wondering, why should tenant petitions be filed against natural persons? Why should we ask tenants to have to file these petitions against individual people if they are not going to be found responsible anyway?
Direct that.
Please, please.
Okay. If your question is regarding harassment or anti-harassment, that is specifically to an actor. So in that regard, yes, obviously a criminal charge of harassment as well is to an individual itself, because they're the ones acting, harassing that person. So in that regard, yes. Obviously for rent leveling determinations, that you have to address against the landlord.
But harassment is that lives under 218, Code 218, correct? That lives all under
No, 260.
260 as well.
260, correct.
Both of those live under our municipal rent control ordinance.
Well, 260-7 is the anti-harassment.
Okay.
And that can be, there's a plethora of reasons where somebody could be harassed by a landlord, right? Or an individual. And depending on what those actions are, will depend on what violation is being sought.
But I guess I'm still a bit confused
Sure.
as to if we know that the outcome can be something like what was found in the state of New Jersey versus Ehrman in July 2021, what else could we be doing in this process? Like, how else could we set up our municipal code, and how else could we set up the tenant petition process to avoid that kind of outcome where these violations are going to be subject to just being thrown out?
So you're specifically asking about legislation, right?
I guess I'm asking, is there a fundamental gap in our municipal code that is preventing us from enforcing Code 260?
Yeah.
Whether it's about harassment or whether it's about rent control.
Right. Okay. So the anti-harassment is specific. For example, if you do not provide heat, right? That can be subject to that 260-7. You would have to name the landlord, the LLC, in that event. In that inquiry, the way we would take that prosecution.
Name landlord, you mean name the natural person behind an LLC, correct?
The LLC.
You have to name the LLC.
You name the LLC. If you're being harassed by an agent of the landlord, in that instance that I'm using, and your landlord is ABC LLC, then you would name the landlord, which will be the LLC, and then that's who we would prosecute.
Okay, and so then what happens if this goes to court? The litigant, the plaintiff, is ruled in favor. What then happens to the LLC and the agents or the members of the LLC?
Sure. So if there is a judgment against the defendant, it will usually result in a monetary penalty. The municipal court is not going to be able to direct a landlord that they must do X, Y, and Z. That's a different court, a different venue. Typically in Superior Court, where they can get injunctive relief is an example of that, where you can go into Superior Court and say, landlord, you cannot do this, or landlord, you have to do this specific action. The municipal court is only can enforce that a penalty, cannot force a landlord to do something.
Okay, so it still seems like there's a risk after all of this of an appeal going to state court, and the agent or the member of the LLC saying, okay, these charges were leveled against the LLC. This has nothing to do with me. Why would I have to?
Well, ultimately, you know, if it's levied against LLC, so when we prosecute, we may, you know, prosecutors are critical thinkers, right? That's why you hire us, so we can critically think. Obviously, if, you know, those folks, a lot of times, and it was referred to earlier, there's a cost benefit analysis. For some actors, they rather come to court and think they're going to pay a fine and commit this bad act because this bad act is garnering them more money than what potential fine will be. When we are assessing that case, we're making that determination, right? So therefore, if we get a guilty plea, we're making that argument to the court that this penalty should be X amount, Y amount, because we want to deter that action. The only way we could deter that action is to let them understand that if they continue to do that, they're going to feel it more than that benefit they thought they had. Hope that answers your question.
I appreciate that. I have some more thoughts, but you want to?
Okay, so as it relates strictly to the LLCs, ABC go to court, they're found guilty, they're assessed the fine. What does the process look like when said LLC don't pay that fine? I know you spoke to some about a lien and
so the liens are what we do when we have these trials in absentia, meaning trials in their absence, or penalty enforcement hearing where they do not appear. We know they didn't appear. The court gives them maybe X amount of time. They don't come back. Then we get a written judgment from the court that we then pass on to our law department to potentially docket and get a lien on the property. Now, other defendants that plead guilty and don't pay the fine, my understanding is the court transfers that into collection.
okay, no, specifically as it relates to the LLCs, you give it to legal and then you said potentially, like what I need to know exactly.
Sure. The reason I assume, I don't think we've ever made a request for a lien to be done and it has not been done. So what happens is once we get that written judgment, we forward it on to our legal department, then they go to Superior Court, docket that judgment, and then that's when it becomes a lien because it gets forwarded down to Trenton and it becomes a lien on the property.
When they try to transfer, the lien pops up, correct?
Correct. So what happens generally is when you transfer a property, when you sell a property, there should be a title search and judgments are revealed. The issue that I'm trying to give strategies to landlords, but I want to address the questions. There are something called quitclaim deeds, where there is no
title search and it
correct.
Goes
okay, so you're aware of that.
I'm very
okay. All right.
So in light of time, our Councilman Griffin also has questions.
You asked my question.
Oh, that was
The liens, yeah.
okay. LLC. Okay, all right. So those are all of the LLC questions. Go ahead, Moms.
Curious to know why, we collected 10,000 in 2024.
10 million.
10 million, 10 point something million, and then 18 in 25, and now already 6+ million. Why we are collecting more fees now this year? We are going to, hopefully. Is there any reason that the number of cases have increased or the staff remains same? What is changing right now?
I can only speculate. I can only speculate that, I mean, I can tell you since I've taken over as the acting chief, certain strategies we've implemented, certain, our the way we handle cases, there are pressure to do, the pressure that I put on these assistant prosecutors to get trial and abstentions done, penalty enforcement hearings. In the past, those defendants were simply put in failure to appear status and nothing happened. Now we're taking the position of, if it's an individual and there's a health issue, a habitability issue, some sort of danger, we're asking for a warrant for those defendants' arrest, right? And if it's an entity and they're not coming to court, we're proceeding in their absence. So one way or the other, we're addressing these cases. In the past, historically, I think that was not the case as much as it is presently.
So, okay. You feel that there are not enough staff members you have. And unfortunately, I don't know what the situation would be going forward and maybe this year. Do you feel that there can be some good softwares or AI help you can take to cut down the labor or the data processing or that work where we can use,
Actually, that is an appropriate question because I just had a conversation with my colleague just a few days ago, the end of Friday, last week Friday. There is some AI software that LexisNexis, our legal system that we use, has. Currently, I don't think anyone in our office has that, and I have requested to get a quote on that. So at least me, as the acting chief, has access to it to see if it's something that cost benefit would work well, that cut down on the menial task. We're trying to do that. And then, as I mentioned earlier, just a few weeks ago, we've exceeded the storage space for what we've made into our case management software. We need a case management software. I mean, that's any effective law firm, I think, has that. I think it would cut down on the menial tasks that we have to achieve to get the functionality we need to prosecute cases. But having an actual case management software, I think, will help cut down on that as well.
Sarah, quick question. As it relates to the liens that's placed on LLCs, can those liens be sold like outstanding taxes? Because it serves two purposes. One, the municipal council gets the money right away. And then two, the bad actor is essentially on the hook for more than that amount because it accumulates interest, which will incentivize them, one, to change their behavior, and two, to pay it quicker.
So Councilman, there's two different kinds of liens. There's tax liens and then judgment liens. We get judgment liens from cases that we get. Those, we can sell them, but not in the same way as tax liens. We can't sell them to a third party who's going to make interest on them. Tax liens are restricted to taxes and
water and, okay.
But also areas where we actually abate the violation, whether it's snow and we clean up the snow, we can charge for that and then get paid back later. Grass, same thing. Or even in extreme circumstances, we're in there fixing the heat, delivering oil where there's no oil in a building, we can get repaid for that.
Councilman Griffin.
Just want to add that there is precedent for that because New York City actually does do that.
Yes. Councilman Griffin.
Yes, so I just wanted to make sure I heard this correctly. So if the landlord does not show up to court, you put in a non-guilty plea for them?
Correct. Pursuant to the court rule, if they're an entity, typically an LLC, it could be a corporation, could be an organization, an entity, the court has the ability to enter a not guilty plea for them. And then as long as they're provided with the appropriate notification pursuant to the court rules, we can proceed with trial in their absence in the future. So what that means is we would have a full-blown trial like we would even if somebody was there, and we have to bring in the inspectors. We would have a full-blown hearing, opening statement, calling our witnesses, entering evidence, closing statements, And then, if the defendant's found guilty, we're able to be heard on what we recommend sentencing to.
So this is based on, excuse me, the landlords or the defendants writing into the court, and then you guys put that judgment in?
No,
I don't understand why we would put a non-guilty judgment in for defendants that don't show up to court, because I know some non-tenants, right, who don't show up to court, and a warrant is put out for their arrest, judgment is placed against them. So I don't understand why we're using that that ability to protect these landlords and give them an opportunity to come to trial when that happens, when the judgment can be placed right there when they don't show up.
Sure, I can answer that. Everyone, whether it's an entity, whether it's an individual, is innocent until proven guilty. We have the burden of proof to prove them guilty beyond a reasonable doubt. And I want to put a pin in that beyond a reasonable doubt for 1 second. But no one is automatically found guilty in our judicial system. We, as the prosecutors, have to prove our case. And if we cannot prove our case, then the defendant will be found not guilty.
He means when the first appearance happens, if they're present, they would enter a plea of not guilty. The court's doing that on their own so that the case can proceed, as opposed to going to failure to appear. That's what the prosecutor means.
Correct. Yes. In case I didn't make that abundantly clear, we are not the ones entering a not guilty plea. It is the court, pursuant to court rules, entering a not guilty plea on the defendant's behalf.
So that the case can proceed in absentia.
Correct.
So, Mr. Prosecutor, I do want to ask, because you spoke to earlier about your connectivity with interdepartments. I do want to ask, what does that communication and that dialogue look like? We have open complaint, code compliance go out, they have a bunch of citations, they write the issues, it goes to you guys. What, if anything, happens after that?
So once we get the summons issued, we actually have code compliance, one of several agencies in the city that upload their discovery, meaning the evidence that we will need to meet our burden of proof. We also have the case information that they can put in any information they think will help us to understand what they witnessed, what they saw, what their thoughts are. And we try to implement that. So once again, we don't have to pick up the phone and pull an inspector off the street or talk to them. You want to add to that?
Yeah, Joe, if you can just talk about what does the back and forth look like? Because we've heard testimony before this council, before this committee previously, where Housing basically said they write the infraction, they give it to the prosecutor's office, and at that point, they're pretty much out of it unless and until the prosecutor's office reach out and ask. And the reason why I say that is because, for one, the better the connectivity, the more accountability. Case in point, if I know as a construction code office that I've issued 6 violations against ABC LLC, hopefully by the 7th, I'm putting an extra note to the prosecutor and say, hey, what happened with the other 6? Because they keep doing the same thing. So clearly there's a disconnect here.
No, so the inspectors write the summons. They put their discovery, their pictures, their memo to file all up in the address in SharePoint, and it goes to court. We speak with the prosecutor. The prosecutors will call the inspector if there's a problem during trial. Instead of bringing an inspector in for every case, we write 20,000 tickets. You can't have an inspector coming in for each one of them. And if we also make a file red if it's a bad actor like that we've hit a bunch of times for different things. And we're in communication all the time. So if they need something from our office, we talk.
So when the prosecutor have come with a package of a plea agreement, do they circle back around with your office, or that strictly reside within the prosecutor's office?
No, most of the time it's pretty much You know, it's up to them afterward. Yeah, it's up to the prosecutor and the judge afterwards.
So we have prosecutorial discretion on how to handle a case. I give you an example. I can tell you in a Title 39 matter, a moving violation, an officer was not pleased with the resolution of the case, right? But ultimately, it's the prosecutor, once again, as the gatekeeper to find justice. Whatever that just result is, we're going to find that. Now, absolutely, we collaborate with our witnesses. We want to find out that information. We just have an internal system currently that is hanging by a string, but it's an internal system to alleviate that daily back and forth because they have a function to do and we don't want to distract them from that function. So we've implemented the system in the past, just so you know, this is many, many years ago. Inspectors would come into the courtroom during the day, every single session. That doesn't get them out on the street doing what they're supposed to do. So we eliminated that completely with this virtual communication.
I do want to ask a question. I know there's litigation with Portside, so I don't want to speak as it relates to the litigation, but I do want to point out the fact that in or around, it may have been last year, I was on a Zoom, and the landlord was cited, I want to say for not displaying where this resident super was located or if there was one. And I thought, I guess I heard it wrong. I thought that the entity had pled guilty and subsequently they were going to pay fines. But it comes back that they went, hold on, Sarah's grabbing the mic, so I may be out of line in question.
You can finish the question. I am going to instruct the witness not to answer it, but we can facilitate a closed session if you'd like to talk about cases that are in or may proceed to litigation.
Okay, well, scratch that. So I guess what I'm just trying to figure out how connected it is because I'm literally flabbergasted that the construction code applying official was saying that there's constant dialogue between his office and the prosecutor's office, and another director is saying, I write the ticket and there's no follow-up. So is there follow-up with some offices and not up? Like, what is it?
We follow up with every office. So I'm not sure where that disconnect is. We, for every witness that we have, when we need additional information, we certainly speak with them. I don't think, now we've implemented a system where we don't need to contact our witnesses. As long as it's an agency within the city, they're able to provide this information of what they witnessed, what the infraction is, their discovery, to help us meet our burden of proof. They provide that. We have discussions with them if we have questions, concerns. If we think there might be trouble meeting our burden, we'll discuss those things with them. But generally speaking, the information that's provided usually is helpful in meeting our burden.
Okay. Well, I guess a better question is, after a case have come to some type of plea arrangement, what, if any, communication you have with said department that wrote the infraction?
Sometimes we do, sometimes we don't. It really, if a plea agreement is based on the information we are getting from that department, we will have previously communicated with that department prior to entering that plea, right? So we know their position in advance of us entering that plea.
But I'm concerned not necessarily with the pending violation, but more so of like the determinant of the repeat violations. What I'm saying, like, is there some type of mechanism that basically says that, hey, this entity or individual has had several violations? Like, case in point, when you're prosecuting a traffic ticket, one of the questions that's almost always asked is, how many traffic violations have you had in the past? Like, there's some type of data that's, communicated in log.
Correct. So in our internal system, and it's I'm just going to give you an example of our code violations. In our code section violations, we have properties listed by their address. Within that, we have subfolders. Our code inspector folder, our health inspector folder, our HEDC folder. Within that, it'll have the dates of each summons or violation. So because on one date, code may issue 5 summonses for ABC LLC on May 10th, 2026. They're going to create a folder in our SharePoint under that address with the date of May 10th, 2026, and upload all that information. Now I'm going to see if January they had another one, November they had another one, because our intercommunication have them already putting that information there.
Oh, so there is a system to track repeat offenders.
100%.
Okay, better. So my next question would be, like how substantial is I know you like to use the word punishment, but the consequence
Sure.
for repeat
Repeat
offenders?
offenders.
Because
Right.
essentially the law is meant to change behaviors,
Absolutely.
right? So I need something to deter
Right.
me from constantly doing it.
Exactly. That's exactly correct. So when we get a complaint in court, we go into our file system, we look at it. If there's a list of other prior incidences, we know as prosecutors, when we're addressing that, they've had a litany of other violations, right? And based on our case notes, right? Because we keep case notes of how we handle those cases. Now, if we had them plead guilty in November of last year, we had them plead guilty in January last year. When they come back in May, it gets higher and higher, right? So when we are evaluating cases, we are looking at aggravating factors, mitigating factors. So if they're a habitual offender, we treat that very differently than that person that has that one offense and they've owned that property for the past 20 years.
I will just say this as my last. I don't know exactly what is going on as it relates to the issuing of the tickets, the consequence behind it, but I can definitively say this. There are several LLCs and establishments in my ward that I don't know if that consequence was sufficient enough because they constantly keep repeating the same offense. I don't know why. I don't know if they just say it's the cost of doing business and they pay the fine. I just know what I see.
Yeah. Councilman, if I may address that, I think Corporation Counsel showed you our enforcement, right? I mean, just the numbers alone spoke volumes to me when she said in 2024 it was 10 million, in 2025 it was 18 million, right? And I want to emphasize we are not prosecuting for dollars, right? But I think that speaks volumes, right? Now, just because, and this happens, just because somebody has come to court, either found guilty or pled guilty, that doesn't mean they're paying anything. They may sit on their laurels and never pay a dime. See, that's a whole separate issue I think that needs to be addressed, is to collect once the fines are assessed.
Okay, all right. Well, in light of all that, I think Tom request, if this committee can get some document that states within the last year, we've issued this many citations, this many judgments have been placed, and we've collected this amount to date, because that'll give us a big picture, because I'm looking at 18 million, and I'm like, hey, hooray, but we could be due 17 million more. So if we can get that. I do want to, because Councilman Rolando has to leave, so I do want to yield to him just to see if he have no questions as of yet. Oh, this is no questions? None?
Defer to my colleague.
What?
I have
Okay,
someone.
Jake, and then, wait, let's let Elena, because she's been patiently looking at her notes. She got everything queued up. So should I
I had some on the follow-up conversation.
Oh, okay,
Yeah,
If
yeah.
that's okay, thank
Okay,
you.
perfect.
To follow up on the follow-up conversation here, it sounds like there is an internal system. You said it's hanging by a string. I mean, and you explained some of the components of you have your folders with, relevant histories in each of the departments. Just would your offices, both for quality of life and for the municipal prosecutor's office, would you be able to produce a kind of memorandum of understanding or a written protocol of the exact system of follow-up that happens between receiving or a summons being issued, excuse me, and then all of the steps that go after that, including the follow-up between the relevant department and the municipal prosecutor's office?
Sure, absolutely. It's exactly as I articulated though, and I'll repeat it, that our system is built so we don't need to make daily calls. If we have questions or concerns or need clarity, or we think we're missing information, we will then reach out to the agency. We've tried to build a system to be as efficient as possible. With the limited resources we're given, time is of the essence. So as long as the department that's issuing the complaint or summons has provided us with the information and has provided us with the evidence to support a complaint, and we can meet our burden, we will use that to plea negotiate, right? And if we resolve the matter, the case is resolved. Generally, a lot more communication comes into place is when our adversary is disputing what this department is providing us. They're suggesting that it's wrong for X, Y, and Z reasons, or that is not accurate information. Then we will take the steps to double check that to make sure our information is accurate that we're providing, because we have to prove beyond a reasonable doubt. And I put a pin in that earlier, and I just want to address that. You as the legislature can change that burden of proof. Okay, you as the legislature can make a lot of our code civil in nature rather than quasi-criminal in nature. Through legislation, we can then seek more penalty enforcement rather than these quasi-criminal prosecutions, right? So that's something I would highly recommend that this committee consider moving forward.
And if that were the case, do you feel like you would have the capacity to actually prosecute if there was a substantially or just substantially enough lower bar as opposed to beyond a reasonable doubt? Do you feel like you would be equipped to prosecute?
If we're referring to the manpower, we're still significantly down on the manpower.
Right.
What that is just the burden of proof. So when we take something to trial, there has to be no doubt in that court's mind that that defendant is guilty of that, right? As opposed to like a preponderance of the evidence in a civil matter, right? It's completely different, a burden of proof, potentially getting more convictions because the bar is lower. And then obviously if somebody fails to appear, there's a different mechanism to proceed in their absence.
I imagine fewer cases would get settled if there were a lower burden of proof.
Well, I think with the quantity that we have, we still proceed with plea negotiations, and because obviously setting up trials is pretty extensive. So the goal is if we can resolve it. Now, the resolution may be a maximum penalty, or close there too, but it depends once again, mitigating aggravating factors, right? I mean, that's what we're there for. That's what we evaluate when we handle a case.
Thank you. And then I just
Can I ask a follow-up?
wrap up
on that?
very quick.
If I may, just as a follow-up, sorry, just one. So you were talking about civil violations, right? So civil complaints. So your office would litigate civil complaints on behalf of?
We do currently, yes. For example, like our penalty enforcements, right? Well, the violations that our fire department sends, we are there strictly to enforce that penalty. Those are civil in nature. So we do that currently. And more importantly, I've been in communication with our corporation counsel about reevaluating our code and making some recommendations that I think will address that. we would still be handling that and prosecuting that in municipal court because there'd be code violations.
I just want to wrap up this. I appreciate that. To wrap this up, for Director Barrow, last session, as I think my colleague was alluding to, Director Richardson gave an unclear answer as to whether there was communication between his office and the municipal prosecutor's office. I brought up the instance of 995 Summit Avenue. Tenants reached out citing harassment from their landlord, and he said that's not our office. I asked to the effect of, so then what did you communicate to the tenants? And he couldn't recall if there was any communication between his office and the tenants as to, hey, you actually need to go fill out this kind of form, go to municipal prosecutor's office. So just with that in mind, that being such a recent kind of admission in the last hearing here, Director Barrow, could you also commit to a kind of protocol of what happens when you get issues that must be directed toward the municipal prosecutor's office or another office in city government? How does your office handle that? What is the clear protocol there?
Well, we speak to the tenant or whoever and give them, the office number or the email of the other department. Or I'll just reach out to whatever department and say, hey, listen, we have a problem here. Here's the contact information. I'll just send them an email saying, we were here. We also, if I find a health violation at a place that one of our inspectors are at, we just, send an email over and they send an inspector. We have a very good communication with the other divisions and offices.
And would you be willing to also spell that out very clearly in the kind of protocol that we can make sure the public is aware of?
If I may just add as a follow-up, I don't know if you all are aware, but we have a quality of life task force.
Yeah.
We go out weekly on that is interdepartmental, right? We're on the spot there at locations communicating interdepartmentally.
I guess the issue that every infraction doesn't cause for the whole task force. So the connectivity that Councilman Efros is speaking upon is, if something comes in and it's not necessarily within your jurisdiction, like how does it looks like? Because the last thing we want is somebody to feel like when they call in the city, we can't provide answers. Like, so if a complaint come in and is Ward E or something, I'll CC my colleague on an email, and from there, I'll step away. So that's basically,
Yeah, we usually by email. We'll reach out to them, give them all the tenant contact information, phone number, everything. That's usually how it works.
I appreciate that. And then just not to beat a dead horse, but I really do. I think this would be helpful if we could get from both your offices here clear protocol of how that communication happens. Would you be willing to spell that out in a kind of written statement?
Yeah, sure.
Thank you so much.
Before I begin my line of questioning, I think Councilwoman Singh, you had a follow-up to Councilman Efforts.
I
No, you have your follow-up.
just, I'm sorry, my questions are pretty basic, so some clarity. About violation penalty, can we increase the amount significantly if we need,
Sure.
we are in crisis?
That is the prerogative of the city council within, a certain reasonableness. You certainly can set a certain standard. For example, in chapter 287, for violations for units from 1 to 4, the minimum is 250. From if the building has 5 or more units, the minimum is 500. So that's something, within reason, the council can legislate.
Especially the big.
If I can just clarify, within the limits of state law, and so state law authorizes maximum penalties for municipal violations. What Prosecutor Kemraj is referring to is that separately, there is a schedule of offenses that are payable. And so what types of offenses you can just log on online and pay it and not go to court? What are the violations that are associated with those? That is currently under review. I'm happy to share that with the committee, but the maximum penalties of $2,000 that you often see throughout the city code, that's set by state law.
See, because for big developers, if amount is not really significant, rather than hiring a lawyer, they would just continue with the violation. So something to think about.
And that's why I think, Mayor, at the end of, last year, he clarified, although it was codified in case law, but there are daily penalties, that can be assessed. And as long as we have the evidence to support that, that's something we can pursue. I'm sorry, Councilman?
Per unit, per day.
It's not per unit. It's a daily penalty for the complaint that's filed.
Oh, well, and no, in some instance, it's per unit per day, unless I'm reading that code wrong. So in some instance, as it relates, is that 260?
No, you're thinking probably of the rent control violations, which
Yes,
yeah,
yes.
and that's something I hope you all understand that's not our office that handles that as a municipal prosecutor. If there is an enforcement of a penalty by the board, we can handle the enforcement, but that is separate and apart through the leveling board.
How do your office enforce said penalty?
We just, once again, it's a penalty enforcement here. If we get that, whatever that rent leveling board says that number should be, that's what we will prosecute and say that's the penalty that landlord should face. Generally, I can tell you landlords, they have a right to appeal that determination through a court of competent jurisdiction, which is not municipal court.
Well,
Right.
once they've reached all of the appeal thresholds and it's finalized that this amount is to be collected, who's responsible for the collection?
Well, that one, I believe when they appeal that up, a court makes a determination, and I will have to defer to our legal department on when it gets to Superior Court, what happens there, or if it gets in federal court, what happens there.
No, but so at what, like, who's responsible for collecting the money once one have exalted all of their appeals?
So let's say there is a judgment.
Yes.
The municipal prosecutor will refer those cases to the law department. We will docket that judgment with Superior Court. That's the point at which it becomes a lien. Historically, the city has not, to my knowledge, invested any resources in actually collecting on those judgments.
So
We are working
no-
on going out to bid for a collections firm that can do that. That is not 100% of the money owed across all cases. Those are just the cases where there is a judgment that has been docketed in Superior Court.
Well, currently, just so the record reflects, we have no mechanism to collect outstanding debt due to the city via collections for the violations.
I wouldn't say
Working on-
no vehicle. There are instances where whether it's the prosecutor or the law department will do things like send letters. If they know the entities, they have called them, but it has always been ad hoc. There has not been a systemic approach to collecting those judgments.
Who's been docketing the judgments in Trenton?
The law department.
That's being done, as best as you know, is that being done?
That's correct. That has been happening. To my knowledge, every time we've received a referral from the prosecutor's office in recent years, the law department has docketed it. That's a fairly pro forma filing. It's not a very complicated thing.
So when the violations, the infractions and the fines have to be collected, it goes to Trenton? Why isn't it going to the county, the register's office, to put the local lien on it? So when they try the quick claim deed and all that other stuff, locally, we will be able to see that.
To a statewide system so that if they try to sell
There you
the
go.
property, it comes up. So I'm sorry.
But at one, it comes back to the county at one point though, right?
So the deeds are at the registrar's office, but if you're trying to sell your property and you have a judgment against you,
Is at the state, yeah.
comes up through a statewide search, yeah.
Okay.
Okay.
So has there ever been a case to where no one paid their judgment and penalties and they've received penalties and then like a repossession of property or anything took place on these landlords?
So when a lien is placed on the property, that lien is good for 20 years. You can go back and try to renew that, but it sits on that property and nothing happens unless there's a transfer of that property, then that judgment needs to be paid as a lien.
Okay, and then I have a question for code enforcement, and Sarah, you may want to jump in on this. What what are the repercussions of landlords, property owners who are constantly in violation and are looking to do business with Jersey City?
That's not something I can handle. We do go back to these landlords. We would do another reinspection and issue more summonses, but there's nothing that I can do to not let them do business in Jersey City anymore.
I can address maybe a portion of that. So our office handles approvals for short-term rentals. So if there's a violation on that property, my office will then check to see if there's any outstanding violations, and we will not approve a short-term rental application until those violations are addressed. So in that regard, we have that internal capability to address it when they're seeking a short-term rental permit.
And Sarah, is there anything that we can do as a council to put an ordinance or a resolution on the books to not do business with constant violators?
So one example off the top of my head of another place in the city code where we link extant unabated violations to things that are within the city's power to grant is with respect to COOs. I believe that the construction official does a search for
Permits and-
violations before issuing those as well. We could work with the committee to undertake a review of other permits, other licenses, other discretionary things that the city gives out and determine whether or not there's already either a law or a practice
Right.
of searching for those violations.
Okay. Thank you.
Also, I guess my latest question as it relates to, so you said the liens are placed on the property for 20 years, and after that, would they evaporate, or you gotta renew it, or what happens? Just,
Correct. So, and I might defer more to Corporation Counsel on that one, but that's my understanding. That, once again, not within the municipal prosecutor's purview, but that's my understanding of the lien law of the state lien law.
so if ABC got a lot of tickets, by the way. So if ABC LLC has accumulated upwards of $100,000 in lien, and they decide to say, hey, well, I'm gonna pass the property to my kids anyway, I don't need to do none with it. So there's no other means of trying to get this outstanding, these outstanding funds. For God's sake, if I miss a quarter of taxes, it go to tax lien, and by the time I had the money to pay it, it's 3 times the amount. And all I did was have financial hardships.
I believe that's a process, and I wish it was different. I wish there was more teeth to it. And I am earlier in our discussion, we talked about piercing the corporate veil if they're that LLC. I mean, those are things I think we certainly need to explore some more. If they're a habitual offender, and there's some health and safety issues at that property. But if they're just racking up, a certain amount of,
Yeah, because I mean, what if they get what if someone gets so many fines that it's better to leave it alone than to try to sell the house because the financial burden associated with it? You're essentially, I mean, it's just, I don't know. For me, it's just like I mean, that granted is 20 years. But I just, it's, from a legislative perspective, Sarah, is there anything we can do to, I mean, if PSC&G, for God's sakes, come after you, the Easy Pass people come after you, Lord knows Viola is coming after you, right? So all of these entities coming after like the regular folks who may have fallen on hard terms.
So the 20-year limit, that's set at the state level. You can kind of conceptualize that like a statute of limitations. The law only gives you so long to enforce your rights and try to achieve remedies. But what we can do is go after them, which we have not spent a significant amount of resources doing historically based on my assessment.
Okay. And we're planning on embarking on that journey, correct?
That's correct.
Okay. All right. Can we allow Council women a little?
Thank you. So I do have my list of questions. Thank you. I'm going to start with a very specific one, if that's okay. And then move on to some more broader ones. Oh, sorry. I hope you can hear me with this mask. I have a cold, so. All right. So Chapter 260, Section 2F1E requires the superintendent's name and dwelling unit number to be filed with the Bureau of Rent Leveling. And Chapter 260, Section 2G separately requires that the same information be served in writing on every tenant and posted to every tenant and posted continuously in a conspicuous place in each building. So before the prosecutor's office tells the court that a multi-unit landlord has come into compliance with the Chapter 260 provisions for superintendent disclosure, what specific documents are in your office's file showing each of the three obligations, that is filing the information being served to the tenants and the posting in the lobby has been satisfied?
Well, the filing, we would rely on HEDC to provide us that information because that's through their rent registration that they would provide that information. And if they have provided that to that department, we rely on them for that information. Obviously, the posting will be determined by the inspector. The inspector goes to the property and sees the posting. We rely on that.
Okay, so in every situation, it would not just be the division of, it would not just be that rent leveling like told you that it was there. It would be that there would also be an inspector, Director Barrow from your office sent out.
Not my office, that would be housing preservation.
Okay.
They enforce Chapter 260.
Okay. And when you're in court, you provide the you would provide the documentation from that inspector?
We would rely on the information. So if the inspector or the department representative tells us that they've received information, we rely on that.
Okay, but there's no, so they could just verbally tell you, yes.
Yeah, we trust our departments and the representatives. If they're providing us with that information, we assume it's correct. We don't generally question the validity of their statement.
Reason to suspect that in a certain case, maybe their verbal assurance was not accurate. Would it be, would this committee request further documentation or?
I apologize. Could you repeat that question? I didn't hear you.
Sorry. And what would be the procedure for challenging that if there's no like photographic documentation or anything like that?
So if you're suggesting that an employee of the city was not truthful, I think that's a larger picture that should be addressed internally to their director. Obviously, depending on what the circumstances is, we do have an investigative portion in the city where where an employee could be investigated if they're doing something wrong. And in the past, we've done that, not necessarily providing us information with prosecution, but just in general, if we feel like there's some nefarious activities, we do have an independent investigation.
Okay.
But what if the employee is actually being truthful based on the procedure? Like you said, going in and seeing something posted and then, okay, it's posted, they're here. But nothing being put in place where it's like, all right, where's this person so I can talk to them, interview them, and, make sure that they're here doing what they're supposed to do on the grounds.
So,
Sorry, Elena.
Councilman, the department or the inspector issues a complaint. That complaint has certain elements we have to meet. If we get information that we cannot meet those elements, then we cannot prosecute. We're relying on that information because what's the point of having that witness come to court, testify, and say, hey, they did X, Y, and Z. When we know that's an element that we allegedly claim they did not do initially with the complaint. So we don't fact check any of our witnesses. We, if we have knowledge that they might be doing something wrong, we may then, take a different course of action.
Okay, maybe I asked the question wrong, right? But it's okay. So what you were saying is they go into the building, if this documentation is posted, that's all they need to see, right? But then you have tenants saying, and they know there's no one physically here. Like, what can we do? And maybe this is a question for Joe. Is there anything that we can do to ensure that these supers are being seen?
Yeah, you would go
On
to,
site.
you would go to the apartment unit that they're living in, knock on the door and talk to them. Not just take the post, not just take the notice. That's what we do in most places when we go check on a super. We make sure we don't just say, hey, do you have a super? We go, well, where do they live? And we knock on the door to see if they're actually there.
When the super's not there, you come back or until you
We issue a summons.
okay, you issue a summons if they're not there for any reason. You just issue.
For any reason, yeah.
Okay, thank you.
But that was my very specific question. I have some more general questions for the acting prosecutor. Thank you. So we know your capacity is sort of a limiting factor with the number of with the number of staff and the number of assistant prosecutors that you have. Are there ever citations that would otherwise be pursued but are unable to be prosecuted due to capacity?
I don't think so. There's a calendar that we receive. We handle that calendar accordingly. As I mentioned earlier, there's about a 50,000 case backlog that needs to be addressed.
So cases are never dismissed just because you do not have the capacity. They are instead logged on the backlog?
No. So if cases are addressed as we get them, and we handle them in normal course. I think in order for us to be current, we need a lot more manpower.
Okay. And so what is the process for working through backlogged citations? And I assume you have a sort of documentation system for all that.
We do not have a documentation for the backlog. That's something that the court has provided me with, that estimated figure. They're the ones that schedule it. We are the enforcement branch of our government. So as the cases come in, we handle them, we prosecute them. I have been in discussions with our chief judge and our court administrator to try to address the backlog. Specifically, we talked about reallocating cases to certain courts to help move the backlog cases along. And we're continuing to have those conversations and to change those calendars to address that backlog.
Can I ask a clarifying question? The backlog is based on the court's calendar, anything over a year, right? Correct? Any case older than a year is considered backlog?
I'm not sure what exactly the court categorized as backlog for the 50,000. I will defer to the court on that.
Well, my question is, you don't have a $50,000 case backlog because there aren't enough prosecutors, because the court's just not getting to all the cases heard because of the volume.
Well, it's the volume is one issue. The personnel is the other issue.
I mean, for example, in Superior Court, in prosecutor's office, civil or criminal, there's cases being heard for trial that are from 2021. That's not because there's not enough lawyers in New Jersey. There's plenty of us. You would agree with me of that notion, right?
Yes, absolutely. Absolutely. But if I may add, as I mentioned earlier, there's a judge sitting in the evenings that the chief judge has constantly been requesting if we can man that, have a assistant prosecutor So we can add some additional cases beyond the parking violations, and we just haven't had the ability to do that thus far.
So, talking about staffing, earlier you said that your ideal would be, so there's 6 courts in the AM, 6 in the PM, and 5 in the evening. And in the evening, you get some help from the law department, but your ideal would be having, at least for the morning and the afternoon, having 6 prosecutors each, and then in the opposite time frame, they can do their preparation work, right? So your ideal would be at least 6 assistant prosecutors. Is that accurate? I mean, 12.
12 in total, correct, yes.
Sorry. And you mentioned about capacity. Last year, you were able to collect 18.3 million in fines. This year, we are not yet on track to reach that number. We are on just proportionally for how far through the year we are. We're a little bit below that, it looks like, but not far off. But we're a little bit below that. But would you say that if your office were to be staffed with 12 prosecutors, would their salaries pay for themselves and then some in the amounts of fines that we could collect?
Absolutely.
So this would actually be a revenue generating mechanism.
Again, we don't prosecute for the revenue, but I think the cost benefit analysis speak for itself.
Yeah, it's just a happy side effect. Okay, thank you. And so going back, Councilor Gilmore had some questions about repeat offenders. If there is a repeat offender that has an outstanding unpaid fine and or an ongoing open prosecution, and there is another case for them that comes, is the process any different if they have that outstanding unpaid fine and or ongoing open prosecution?
So it's this is an issue I've been addressing with the municipal court, because we are working with them to consolidate matters. So when a litigant comes to court, he may have a violation from April, he may have a violation from February, he may have a violation from January. And because of the way it's currently processed, when it comes in, he may have a court in one courtroom on one day, in another courtroom on another day, and in another courtroom on a third day. And I think they're struggling with the manpower themselves, because we've constantly been trying to get them to consolidate all that, including outstanding time payments. So if a defendant previously came to court and was put on a time payment plan, and we want that matter consolidated with all their other open matters. So one, if they need an extension on that and they have a plausible reason for that, they can address that with the court. And two, we can also address all their matters at one time. And that as well will prevent a litigant from going to multiple courts. But more importantly, I think it'll be more effective prosecution.
Next question is, what, if any, mechanisms are in place to protect tenants from retaliatory actions from landlords if tenants are to lodge a complaint and bring it to court or even serve as a witness in court? Are there any mechanisms in place to protect them against retaliation?
So we do have the anti-harassment section in our municipal code. There are state laws that they can pursue as well in Superior Court. I don't think a tenant should feel apprehensive about coming to court and assisting in prosecution or being a witness for the city or state. There are laws to protect our witnesses.
So if a developer is repeat offender, repeat violation he has on his name or the building's name, that is it possible to, and this is the question for you, Sarah, is it possible to have their information public?
Correct me if I speak out of school here, but violations, citations, judgments, fines, whether or not they're collected, that's all public record. That's record that anyone in this room could submit an Oprah request for. It would take a lot of time to compile because a lot of that information lives in different places. There is no one central repository of here's the complaint, here's the inspection, here's the citation, here's the judgment, here's the fine. But that is all public record. So nothing legally would stop the city from making that information more readily available.
So because people around the world come here to live, and if when they look for an apartment, if they Google this developer, is it possible to get the access of, or possibly finding, okay, you know, this is a bad landlord, because then you don't get stuck in that hole where you are stuck now. You have signed the lease, because you literally can't go through the lease, by the way. If you start reading everything, you would never sign the document, but you'd sign, right? Because we just can't read all that. Legally, we are not that, you know, we don't have that knowledge. So I'm just trying to see that how these innocent people moving here, going to a bad landlord and then getting stuck for a year or more, because they have no idea about all the, how the law work and the behavior of this bad landlord.
Just to clarify, when I say that those are public records, what I mean is that the public has a right to access them, has an entitlement to that information, not that that information is in fact available to the public or readily available to them or easily available to them. So it would be up to the city to invest the resources, design the system that would let the public easily access that information.
I actually have a follow-up question about your comment on leases, and I think this question is for Corporation Counsel, most likely. I talked to a tenant in one building in my ward who said that in her lease had a provision that says, by signing this lease, you are waiving your right against unconscionable rent increases. Is that something that can be waived in a lease, or would that lease not hold up in court?
So the law department can only provide advice to its client, the city council. We can interpret our code. So I'm not in a position to provide any legal advice for any third parties, but unconscionability is a common law doctrine. It is developed by state courts. So ultimately, it would be up to a court, not up to a landlord, to determine whether or not that rent was unconscionable.
But the lease stated that she was waiving her right to pursue claims for unconscionable rent increases.
Nothing would stop a landlord from trying to enforce that term. I find it really hard to believe that a court would enforce that term.
Director Burrow, if you can help me understand, if someone it's in violation of their CO, and a citation is issued, it goes to the prosecutor's office, to LLC, and I guess a fine is levied against them. What internally, how does said entity get permits to do anything else?
So I don't handle COs. That's the construction code. We don't file violations for COs. There is
You're in the office that files COs. All of you guys are together, right?
no, completely different departments.
No. What I mean, yes, different department, but we're all under the same entity. We're all doing the business of the city. So my question in asking you that is how you alluded to the connectivity to the prosecutor's office. I want to know what if any connectivity do you have to enter departments or other divisions?
Oh, I work very close with every other department. We're on the task force every week together. I speak to departments multiple times a day. So if there is an issue, if there is a construction issue, I know who I can call right away and get that inspector there immediately, and that inspector will go there immediately.
So my question is, how does someone who's out of compliance as it relates to a CL can obtain permits to do other things.
That's not, because I don't handle the COs. That would have to be under the construction code. That's how, I wouldn't know how.
Or
that-
you wouldn't know if you wouldn't even know if the CO is not valid or not?
No, not my department, not my department. The construction code would, and zoning would.
Confused. So each department doesn't know if there's pending violations?
No, not separately. Like, you know, I'm sure with bad landlords, I'm sure that every department has violations against them, but as far as checking for COs, I don't have the ability to do that. That's just construction code and zoning.
Do you feel like,
Thousands of cases, how would you know them by name? One department to other department, you are saying, yes, we generally know the bad landlords. But I'm just saying that how would you remember the name of all bad landlords if you are not communicating with other departments?
Well, because we're there for different reasons. So you kind of, if you're doing this for a while, you know who's a bad landlord and who's not. You know, there's different addresses that we always go to, different things.
Which I think, so every time we do a ribbon cutting, right, and we work for the city, one of the main things we do is verify that the space we're going to cut the ribbon has a valid CO.
Yeah, but that's not, there's people that do that. It's just not me.
Is there someone in your office? There's no one in, so your office is responsible for doing what exactly?
We handle housing. We go after landlords. Like if your landlord doesn't act, we do a housing investigation. We handle sanitation issues. We handle sidewalk defects. We handle street closures. We handle entertainment licenses, licensing things through commerce, enforcement like that. COs are handled by construction code and zoning. That's it.
And then permits are handled by who?
It depends on the permit. The construction code permit, construction code. Yeah, that's not my office at all.
But you guys are in you guys are all under HEDC, correct?
No, I'm under public safety.
Oh, you are quality.
So, yeah,
Oh, my,
the quality of life.
no, Joe Barrow and oh my goodness.
Oh, that happens a lot. I'm sorry.
That's
I'm not
what
Joe
I'm like.
Severini.
It's been a long
Okay,
evening.
okay,
Maybe
yeah,
the witnesses
yeah.
can re-identify themselves on whether we're.
can
No, I
I,
just think,
Not the
Joe,
first
that's-
time that happened this week.
Okay, okay. Oh,
do we think it would make your lives and your work easier if there was a kind of centralized system where someone, you know, an LLC, a property owner comes up for whatever kind of code violation might be coming through quality of life, and you could get pinged that, hey, there's this whole other list of outstanding violations that are relevant to the other departments in the city. Do you feel like that would be helpful in the kind of work you do on a day-to-day basis to have that additional information?
Yes, and we do share information with each other. Like I said,
Sure.
I'm in communication with every division, usually every day about different properties, different inspectors, you know, and so we pretty much know what's going on with other places.
So
Once the violations are issued, then it's out of our hands. And
Okay. It sounds like that information exists through kind of word of mouth, as opposed to there's a centralized system.
Well, we can also access SharePoint where we put up our
Right.
discovery. So we can actually see the other departments when they, you know, well, health issued a violation to, 35 Kensington,
Right.
construction code was there. They did this. You could see all that in SharePoint.
Okay.
Okay.
I guess my question for the prosecutor, if there's because there's this lingering issue about a CO, and I don't know exactly what happened because the city's position and the establishment owner position is contrary to one another. One saying that they submitted the appropriate paperwork, and our position is, well, they didn't submit what they said they was putting there. So I say all that to say, there's an outstanding violation that's been outstanding for probably over a year. And I'm just scared that if it's an issue with occupying the building, i.e. the certificate of occupancy. The last thing I want to see is something happen to someone that's there and then someone file a lawsuit and everybody's looking at the city like, well, they weren't even supposed to be open. Why are you guys prohibiting them to occupy the space when there's no approved CO? So I'm just trying to figure out like, and it's kind of alludes to the issue earlier of how do we go after people that owe money? How do we enforce the actual laws that's on the books? Like, what do we have at our disposal? Can we go and remove them from the premises? Is that an option? Because the last thing also, I don't want everybody to say, well, you know, they really can't do nothing. We don't got a CO. We still won't stay open. They ain't got no mechanism to collect the money anyway.
So there are certain reasons that are both our city code and administrative code permits closures. For certain health violations, for certain construction violations, if the building's structurally unsound, those are reasons that folks can be removed from there, and if their tenants can be relocated.
How does that removal look?
I actually, Director Barrow is one of the key personnel that handles relocation.
Well, for relocation, not for shutting down the business, I can't do that, but for relocating tenants, like you said, working with the health department goes into a place and sees something that's uninhabitable. They come to me, I issue the order to community development. Community development works with the tenants, puts them up either in a hotel or they can get $4,000 in funds to go find a new place, you know, go find for a down payment on a new apartment somewhere. However,
At whose
they choose.
expense?
If those are federal grants, so then the federal grants, once they go to court and summonses are issued, that's how the city recoups the federal grants.
Oh,
That's a better question for community development. I don't know all the ins and outs of it completely, but I'm the one that issues the order.
Okay. Yeah, Mr. Prosecutor, you can finish on your thought.
But I just wanted to address Councilman Afros's question. If there was a centralized system, I think that would be helpful because that would let all the agencies know. I know this is something that has been in discussion for quite some time regarding some centralized system. The issue of denying someone the ability to do certain things because they may have an outstanding time payment or, requesting to pull a permit, there's some legal issues with that that may limit the city's ability on denying that, depending on the circumstances. But a centralized system would at least put folks on alert so we can try to address those issues.
I appreciate that. Would you anticipate that those legal limitations would be statutory or would they be existing within our municipal code as written?
It's statutory.
Statutory, okay. And then if I can just go to an example briefly of where I feel like this kind of inter-office communication would be especially helpful, again, to bring up 995 Summit in the Heights. The owner, Isaac Sabag, failed to obtain construction permit. It looks like what's owed is $6,000 for the failure and then $42,000 over time from $1,500 per week since October 8th, 2025. We have all these violations. The staffing was there to issue the notice and order of penalty, but I don't know if, this is an open question, have we collected any of that almost $50,000 from Isaac Sabag? And now units that were under construction appear to, the information I've been given from tenants, appear to actually being rented out at illegal rental rates. So I just want to cite this example as a case when this exact kind of inter-office communication should be going on so that we can really get a handle on these slumlords before they go ahead and violate code for months, if not years, and then start illegally renting out units way beyond what is in rent control. I know I've been bringing up this case a number of times, but if there's any information that you have about those kind of outstanding violations at 995, that would be very helpful. If not right now, then I'm happy to follow.
I'm not sure if there's any specific litigation. I can tell you once we prosecute, the collection is then handled by the municipal court, or if it's referred for judgment, then it's docketed. So that'll be beyond the municipal prosecutor's scope.
Okay, thank you.
Municipal court used to be good with coming at the people who owed fines, if I can recall correctly. I mean, I don't know what happened since then. I just think like there has to be other, like there has to be other triggers. Again, if it's a traffic violation, there's a fine assessed. If you don't pay the fine, your license can get suspended. Then you have to pay a restoration fee. Then there's even mechanisms where registration can be suspended. So not only can you not drive, no one can drive a car you own, right? There's all these instances where certain thresholds are reached for individuals. So is it the opinion of your office that prosecuting entities are drastically harder versus prosecuting individuals?
Well, I do want to remind the council during a period during COVID, those license suspensions were not taking effect. Those registration suspensions were not taking effect. Warrants were not being issued. This is what accumulated or was a contributing factor to the accumulation of this large backlog that we have. Now that that has been reverted or rescinded, I should say, and now they are license suspensions, they are registration suspensions, they are now warrants being issued, and I think that's one of the contributing factors of why we're getting folks to appear. Entities, absolutely, right? Because there is not that consequence of them going to jail, right? With an individual, there's a warrant issued, they can go to jail. Depending on the penalty, they can go to jail. As an entity, you cannot put an LLC in jail, right? Unless we are piercing the corporate veil to get to a member.
I mean, I think that's part of the problem that we're having is these entities. And I get a lot of it is state law. You can't really tell someone they can't have a LLC that own a property, the LLC that manage the property, LLC that's a investing member. You know, it's hard to navigate those waters. I just think internally, again, speaking to this interdepartment network, and there's things that we can do, you know, to essentially kind of make life hard for them. Because I mean, if I'm an entity and I know and understand that I need permits to do X, Y, and Z, fine, I'll just go do the work. I'll get the fine. I ain't got to pay it in 20 years anyway. In the meanwhile, I'll just be renting out a illegal apartment, accumulating money, right? It's cost effective. I don't have to go to the rigorous screens of going through a process that's going to cost time and money. I can almost like circumvent the process, get the tickets, acknowledge the tickets, see that they're there, and then there's no real mechanism to collect it. So therein lies the frustration of everyday residents, right? Because residents are looking and saying, hey, councilman, following up again on this building, they're still doing X, Y, and Z. Oh, by the way, I got my car towed because my registration was suspended. I forgot to pay it. Right? So in one light, we're like, well, your car was supposed to get towed. You should have renewed it. But in another light, you're saying that, you know, these entities can pretty much run amok. And that's the real frustration for the council, because we have to fill these questions, comments, concerns every single day. So, you know, this committee in part is tasked with bringing you, ladies and gentlemen, here, asking you the hard questions, trying to see what are your strengths, what are your weaknesses, what are the threats. That's my business SWOT analysis education on display there. But opportunities to definitely. And we're tasked with trying to find a way to give our constituency answers. Because I'm gonna be honest, for me, it's hard to look a resident in the face who had the same issue or the same issue with an establishment for over 2 and 3 years, right? Because it looks like, you guys aren't doing anything and they're getting away with everything. And that's the frustrating part every single day, right? So, we're going to make recommendations to the administration. We've heard your concerns as it relates to manpower. I can't assure you that we'll be able to get you guys more manpower, seeing that the deficit in which we are facing. In fact, I can't guarantee you'll have the manpower you have now. But, we're just trying to find ways in which we can hold bad actors accountable. And we know and understand that all landlords are not bad. But damn it, the ones that are bad are horrible. And therein lies the problem. So does anybody have any questions, comments, concerns, or follow-up before we conclude this meeting?
So I had one more question for the municipal prosecutor, and I did have a few questions for Director Barrow as well.
Yeah.
Oh, sorry. Yes, I had one more question for the municipal prosecutor and a couple more for Director Barrow as well, but I noticed we're not at quorum, but I think Mamta's coming back. I think she just went to the bathroom.
Hey, Councilman Griffin, if you can wait right here until Mamta come back so we could be in quorum.
We need you on the dais.
Yeah, if you could come up.
Yeah, at this level, we have to take turns going to the bathroom, unfortunately. And hopefully Councilwoman Singh will return soon. So my last question, and I told you I was saving the broadest one for last. You talked a lot already about some of your suggestions for improving the functionality of the municipal prosecutor's office, but do you have any other suggestions on how the municipal prosecutor's office can be more effective?
I think I've touched on the items that I think will certainly equip us with the tools, because I know some of my requests may be aspirational with the amount of manpower, but just, any additional resources will help. The case management software, the additional manpower, I think those are steps in the right direction to get us on the right course. I think we're an effective office currently, and I think we perform at a high level. But I think we certainly can fine tune what we have, provided we have the resources to do that.
Thank you. I want to open it up in case anyone else had questions for Municipal Prosecutor Kamraj or Director Barrow before I launch into my questions for Director Barrow.
Yeah.
Okay. So when a complaint is submitted to your office, what is the process and typical timeline of determining if a violation has occurred? And what is the subsequent process of a citation being generated and submitted to the municipal prosecutor's office if a violation has occurred?
So we have a pretty good response time, usually in a day. That day, the inspectors there, they have the complaint system on their phones. It gets sent to them when the complaint's assigned to them. They're there immediately. Normally, especially with a housing complaint, they're probably there that day, if not the early next morning. They issue the violations that day. When it comes to housing, they have the landlord has 30 days to abate the issue. If they don't, then then it goes straight to summons.
Okay, thank you. And does your office ever follow up with the municipal prosecutor's office on citations to see whether they've been prosecuted, to sort of check the status? Or
In certain cases, yeah, we'll speak about, especially repeat offenders and bad actors.
Council, you leaving? We have to have a quorum.
I just have one question
Got a
left.
couple more questions. You can hold on.
I have one question left. I'm so
Thank you.
sorry. Are violators subject to increased inspections for a period of time?
Yes, but yeah, absolutely.
And can you talk?
We'll
about
go
what that looks
back, we'll
like?
go back and make sure that, yeah, that the problem was fixed.
Okay. Okay, I'm done. I'm sorry to keep you all late.
Oh, that's, I mean, this what we were tasked with. So if, Mr. Prosecutor, I guess, or, Sarah, if we can get those requested documents, that Councilperson Zupa have requested, and also, a copy of, or a list of all infractions that were collected, all that were guilty pleas or guilty verdicts, in the amount, in the outstanding amount, that'd be, helpful as well.
And if I can just reiterate the request for some written protocol on the kind of interoffice communication and the follow-up procedures, that would be extremely helpful as well.
Yes, if you can
Thank you.
send all three of those to all, you can send it to legal, and then legal, she will forward it to us.
What would be helpful is if the committee could compile its data requests, because we have already put in a data request with the court administrator.
Okay,
Their system is not set up in a way that is particularly straightforward to query, and so it is taking a
Some
meaningful amount of manual time to compile that information. So if you could give a priority, we'll talk to them and figure out if it's easier for them to pull it by year, if there's a way we can do it on a summary basis that reduces the administrative burden on them. But
do
if you could just put together your list of data points, we'll confer with them and do our.
the court need more staff too, or they good?
I'm sure if you asked them to come here, they would tell you all about it.
Okay, I just want to note it is difficult for us to coordinate a list of questions because we can't really talk in a group outside of this committee because of sunshine. But maybe if the three of us want to coordinate on those.
Yes, we'll send, Sarah email just to follow up.
Okay.
That way
Or-
they have everything in writing and they know exactly.
Or yourselves and Councilman Zupa, I'm also okay with that arrangement. But yeah, if we can just.
Council Chair, may I ask a question of legal? Is it in violation of the Sunshine Law for all councils to be on a shared document?
You are discussing the business of the governing body, I would advise against it.
Not discussing, but like they have questions, compiling questions.
That could be a discussion. If there's just a document that is shared with all of you that is not a forum for discussion, then that is a safe zone. But if you are specifically creating a forum to discuss. then-
No, not a forum. So I'm having all council send me the questions and I'm putting them all on one document.
If you are facilitating a back and forth, so for example, if council is submitting things that are populating in a document and then there's subsequent questions about what other people are putting in the document, I would say submit all of your information. If you could compile it in one final document and then circulate it, then there's no
In a
question
final
that there's
document.
any discussion happening.
Okay, so don't share it with everybody until it's finalized.
No back and forth.
Do we have our date for the next meeting?
The second Monday of every month.
Yes.
Right, so that's June 8th, 9th. June 9th.
June 9th.
Okay,
The
Yeah.
first is a Monday, so June 8th.
June 8th.
June 8th. So I think we should, pause as it relates to. all of
Hold on.
when.
Because of the way it's set up, in this case, it looks like June 8th is caucus.
It is?
First is caucus on my calendar.
Oh, my calendar's just wrong then. Sorry about that.
On what? On the 8th? How would you set the caucus on our date?
Oh, because of the summer.
Yes, the summer.
Okay.
Well, no, isn't that the?
So no, it would be the 15th then. It has to be on a Monday.
Okay, June 15th.
That,
I want to say thank you so much for coming out to answer our questions.
No, absolutely. I want to take this opportunity to thank the committee for giving us the opportunity to come out and address any concerns. And I encourage you all, if you have questions, to reach out to my office. We are more than willing to share. I believe the line of communication as per your own questions and our interdepartmental communications, I want you all to feel free to do the same. Obviously, there might be some issues if there's a pending litigation, what information I can disclose or not disclose. But I think having the information will be able to you all to address your constituents when they have questions. I can testify to you that our office, I believe, is running on all cylinders. If you provide us with the equipment, we can exceed and excel. But I implore you all, feel free to come and witness us, look at us, see what we do to witness for yourself rather than just taking my word.
All right, thank you. So we going to, what's the 15th is the next one, is the following Monday? Yes, if we can, yeah, we'll do the 15th. And then we'll take that time to reconvene amongst the group, just to discuss what we've gathered so far, what recommendations, what our next step, kind of like to bring a little more structure into the committee. And then I guess that following month, the following month, we'll call the former municipal prosecutor and then whatever entities or individuals we need to talk to after that.
Thank you. One quick comment that was on the agenda that I don't think we got to. Secretary Walker, the clarification on committee deadlines, the 90-day rule. I wanted to clarify what was the intent of the council member who was drafting that I'm so sorry. Thank you. I told you I was sick. I think the deadlines were a little ambiguous, and so I wanted to seek clarification on that.
For the, which specific?
For the interim report, is that right?
The 90-day report, Erica, you were saying the 90-day report. I think we need to clarify on the record that deadline.
Yeah, so the intention was for the 90-day report to come after the last public meeting, not 90 days from the start of the committee. I don't think-
Yes, it's the last meeting.
Okay, 90.
So after we've convened all the meeting, talked to all the individuals, whenever that last meeting, whenever we say this is our last meeting, we have the 90 days starts. That's when the 90 days start.
Okay, and that was the intent when you were drafting.
Yes.
And that would be 90 days from we have a 6-month run of this.
No, we also
about
have
1 year.
yes, and we also have the ability to extend too.
Okay.
So case in point, if we don't get all of the necessary information we feel we need,
We vote to
within the allocated
extend.
time frame, we'll extend it.
Okay.
We don't want to handicap ourselves. Motion.
I hear a motion from Councilman Gilmore to adjourn the meeting, seconded by Councilman Efros to adjourn at 7:33 PM.
Hi, sorry.
All in favor?
Aye.
Meeting adjourned at 7:33 PM. Have a good evening.
Thank you, everyone.